NVIDIA's CEO says U.S. export controls are backfiring as the company's losing billions in lost sales to China. Getty Images CEO says we can't afford to fight every AI copyright case. And as Shakespeare said, first we fact-check all the lawyers. Okay, yeah, that quote was made up. Welcome to Hashtag Trending. I'm your host, Jim Love. Let's get into it. NVIDIA's CEO Jensen Huang delivered a stark warning to U.S. policymakers. Export restrictions on AI chips are strengthening Chinese competitors while costing his company almost $8 billion in quarterly revenue, a sixth of its total business. Despite maintaining a 90% share of the global GPU market, NVIDIA faces mounting pressures from Chinese rivals like Huawei, which is set to begin mass shipments of its Ascend 910C AI chip this month, while preparing to test an even more advanced 910D processor. Shielding Chinese chipmakers from U.S. competition only strengthens them abroad and weakens America's position, Huang said during the company's Wednesday earnings call, calling China a springboard to global success with half the world's AI researchers. The financial impact is severe. After the U.S. government required licenses for NVIDIA's H20 chip exports to China in April, the company took a $4.5 billion charge and expects to lose approximately $8 billion in H20 revenue next quarter, money that was previously flowing from the $50 billion Chinese AI market. Huang's frustration reflects a broader strategic concern. China is developing domestic alternatives whether American chips are available or not. China's AI moves on with or without U.S. chips. It has to compute to train and deploy advanced models, Huang emphasized. The restrictions have accelerated Chinese innovation, though. Huawei's new Ascend 910C combines two processors into a single package, doubling computing power, while companies like Cambricon Technologies are optimizing major AI models like Qwen 3 to run on Chinese-made hardware. Meanwhile, NVIDIA and AMD are scrambling to develop neutered versions of their chips which comply with U.S. restrictions. NVIDIA is reportedly preparing a B20 chip for China, while working on a lower-cost Blackwell-based processor priced at about $8,000 U.S., significantly below its current H20 model that sells for $10,000 to $12,000 U.S. Despite the China setback, NVIDIA reported strong overall results in Q1 revenue, up about 69% year over year. The company is expanding AI factory partnerships in Saudi Arabia, UAE, and Taiwan, while building domestic U.S. manufacturing capabilities as well. But Huang framed the issue beyond immediate financial losses. He said, "The AI race is not just about chips, it's about which stack the world runs on. And that stack grows to include 6G and quantum, and U.S. global infrastructure leadership is at stake." Huang pointed to China's DeepSeek R1 and Qwen models as evidence that export controls haven't slowed Chinese AI development at all. Instead, he argues, they've created an incentive structure that drives innovation away from American platforms. The question now is whether the U.S. will adjust its approach or continue policies that Huang believes are inadvertently accelerating the development of Chinese AI independence. Getty Images CEO Craig Peters revealed the stark financial reality facing companies trying to protect artist rights. Even a major player like Getty cannot afford to pursue every AI copyright infringement case, spending millions and millions of dollars on a single lawsuit, while tech giants move fast and break things. In a candid CNBC interview, Peters exposed the David versus Goliath economics undermining copyright protection in the AI era. While companies like Stability AI generate massive revenues from AI models trained on copyrighted content, the content creators and their defenders face prohibitively expensive court battles they often cannot sustain. Even for a company like Getty Images, we can't pursue all the infringements that happen in 1 week, Peters explained. We can't pursue it because the courts are just prohibitively expensive. We're spending millions and millions of dollars in one court case. The admission comes as Getty battles Stability AI over allegations that the company copied 12 million Getty images without permission to train its Stable Diffusion AI system. And while Stability acknowledges using some Getty images, it claims fair use protection, a defense that forces expensive litigation to resolve. Peters rejected AI companies' arguments that paying for content access would stifle innovation, calling it a world of rhetoric, and used to justify unfair competition. He characterized the prevailing Silicon Valley ethos as disruption under the notion of move fast and break things, but emphasized that what these firms are doing is theft. The financial imbalance is staggering. AI companies have investors with very deep pockets, and they can generate billions in revenue from models trained on copyrighted works, while content creators face years-long battles costing millions just to defend their basic rights. The economic asymmetry effectively allows wealthy tech companies to outlast smaller rights holders in court. Getty's case represents just one battle in a broader war engulfing the AI industry. The New York Times is suing OpenAI, record labels are targeting AI music generators, and artists worldwide are discovering their work used without consent or compensation to train systems that could eventually replace them. The situation creates a perverse incentive structure. AI companies can afford to risk infringement lawsuits because the cost of litigation often exceeds what content creators can bear. Even when rights holders win, the years-long legal process and massive expenses can prove that you win a Pyrrhic victory. Peters noted that Getty has expanded beyond courtroom battles, advocating for stronger copyright protections in policy discussions and urging the U.S. government to reject proposals that would weaken artists' rights for AI development. The fundamental question remains whether copyright law can survive in an era where the cost of enforcement exceeds the resources of most of the content creators, while companies profiting from their work possess virtually unlimited legal budgets. I must have read a dozen or more stories over the past year where lawyers have gotten caught with fake precedent cases and the judge castigates them and threatens to fine them. We don't even really cover them anymore. There's just so many of them. But if you're like me, you would ask, why do they keep doing this? Aren't lawyers supposed to keep track of what's happening in their area of practice? There have been at least 7 documented cases across U.S. courts resulting in fines and disciplinary action. And I personally know of 2 cases in Canada which we covered, which made news and were horribly embarrassing to the lawyers involved. In the U.S., personal injury law firm Morgan & Morgan sent an urgent email out this month to more than 1,000 lawyers, and it said, artificial intelligence can invent fake case law using made-up information in a court filing, and it could get you fired. The warning came after a federal judge in Wyoming threatened to sanction 2 of the firm's lawyers who included fictitious case citations in a lawsuit against Walmart. Attorneys from Mississippi-founded law firm Butler Snow apologized to U.S. District Judge Anna Manisco in Alabama after they inadvertently included case citations generated by ChatGPT in 2 court filings. Meanwhile, lawyers at major firms K&L Gates and Ellis George recently faced similar scrutiny from a special master who discovered their brief contained non-existent cases. Stanford law researchers have actually quantified the crisis through comprehensive testing. For then state-of-the-art models, the hallucination rate, that is, the propensity to make up facts in legal cases, was between 58 to 88% in their tests. A separate study found legal hallucinations are alarmingly prevalent, occurring between 69% of the time with ChatGPT 3.5 and 88% with Llama 2. The infamous Mata versus Avianca case set the precedent when U.S. District Judge P. Kevin Castell in Manhattan ordered lawyers Stephen Schwartz, Peter LaDuca, and their law firm Levido, and Oberman to pay a $5,000 fine for submitting 6 fabricated case citations. The judge found the lawyers acted in bad faith and made acts of conscious avoidance and false misleading statements to the court. And the sanctions are escalating across jurisdictions, and some of them are getting to be creative. A Texas federal judge recently issued sanctions in the form of a $2,000 penalty and a directive to attend a continuing legal education course on using generative AI in the legal field. Even cases involving high-profile figures like Michael Cohen have drawn judicial attention, with one judge calling such incidents embarrassing. The widespread nature of the problem reflects AI adoption in legal practice. According to Thomson Reuters' 2025 Generative AI report, 26% of legal organizations are now actively using Gen AI, up from 14% in 2024. While only 15% of law firm respondents say Gen AI is currently central to their workflow, a striking 78% believe it will become central within the next 5 years. While AI tools help reduce research and drafting time, the fact that these models can confidently make up facts creates new professional liability risks. But I'm still mystified by this. I have to do a lot of research as a writer. Many people who use AI have to do research. It's one of the biggest things that it can do. So I use ChatGPT and Claude, occasionally Grok and Gemini. I find actually Gemini more likely to hallucinate. Now, I haven't kept stats, but I'm sure that I get well under 1% hallucinations. How do I know that? Well, I do a lot of research. I let AI do the heavy lifting, but then I pull the original paper or story and I check it to make sure the facts are right. Even when I'm writing fiction, my last novel, Alyssa, A Tale of Quantum Kisses, had typos in the final manuscript of the book because I wrote it, but any scientific fact was accurate. But what is it about legal work that makes AIs have such a high rate of hallucinations? I had to cull through 13 years of historical data to write up one story for a project I'm doing. I absolutely used AI to do that. But I asked AI to give me its sources, and then I used a second AI to check the sources, see if they're credible. Writers and reporters do this all the time. We make mistakes too. And even the original material can have mistakes. So why are lawyers so lax about this? Why do the people we absolutely count on for facts appear to be the sloppiest at validation? And that's our show. And it's 100% accurate to say that we like to hear from you. Thanks to all of you who wrote me on the weekend. Our Project Synapse show continues to gain audience, but we can always use more. So if you like the show, please let a friend know about it as well. And if you want to support us more, please consider going to buymeacoffee.com/techpodcast. That's buymeacoffee.com/techpodcast. Go there and, well, buy us a coffee. Without your support, we wouldn't be able to do this. So thanks to all of you who've gone to buymeacoffee.com/techpodcast. You are the best, and that's a fact. I'm your host, Jim Love. Have a terrific Tuesday.